Everybody, Joe Brunsman here, back with another video for you. I was actually going to make a different presentation on the limits of cyber insurance, and then this popped up, and it was simply too juicy for me to let go. So this is an example of an FTC data security action. This is for a company that's about, I think, around 20 million, according to Dun & Bradstreet. Keep in mind, these are all allegations, but we're going to really get into actually why you probably need to spend more money on cybersecurity. So let's just kind of jump into, first we're going to talk about the complaint, and then following that we're going to be talking about all of the 20-year consent order that this company has agreed to. So let's jump into it. All right, so this is just really a quick copy of the complaint. I've highlighted the relevant parts. These are the allegations for InfoTrax, and they're further known as respondent. They've operated a technology company that provides back-end operation systems and online distributor tools for the direct sales industry. Their clients are primarily multi-level marketers, which rely on InfoTrax products and services to manage all aspects of their business operations, including compensation, inventory, orders, accounting, training, communications, and data security. Operative term there. They operate the major aspects of their clients' website portals for their distributors and customers. In the process of registering and placing orders, distributors, on behalf of themselves and their end customers, supply InfoTrax with significant amounts of personal information about themselves and their end consumers, which may include, and this is really important here, dates of birth, physical and email addresses, telephone numbers, social security numbers, other government identification numbers, payment card information, including credit or debit card numbers, card verification values, also known as CVVs, expiration dates, bank account information, including bank account and routing numbers, and account user IDs and passwords. So essentially, they are collecting everything you would consider pretty much as PII. Obviously, there are rules in place on how you need to secure that at the state level. At the federal level, it's not as, apparent, because the FTC really works on something called reasonable data security. Now, what is reasonable data security or reasonable cybersecurity? Well, what's reasonable to you, in your opinion, may not be what's reasonable to the FTC. So that's why we have to continuously read through these orders to figure out, what is at the federal level that the government's saying these are things you need to be doing. This particular case had a really interesting extra in there, but we're going to get into that in a second. All right, as part of providing products and services, InfoTrax assumes responsibility for the security and confidentiality of consumers' personal information by contract and purports to ensure that all personal information is adequately protected. As of September 2016, respondents stored personal information for approximately 11.8 million consumers. Now, what's interesting here, this came out, well, it looks like we don't have the date on this. We'll probably see that at the very bottom, but these tend to take quite some time, which is not fun. Now they get into what are considered unreasonable data security practices. Now, previously, remember I told you that they have something called reasonable cybersecurity or data security practices. They don't define what that is. They kind of just come in after the fact and hammer you for failure to do that. So let's look at what the FTC thought InfoTrax unreasonable data security practices actually were. They are alleging that InfoTrax failed to have a systematic process for inventorying, deleting consumers' personal information stored in their network that's no longer necessary. So obviously, data retention is a cybersecurity issue. Make sure you're taking care of that. They failed to adequately assess the cybersecurity risk posed to consumers' personal information stored on their network by performing adequate code review of InfoTrax software. Now, previously, I was actually on, I think it was like a Zoom call with Dave McHale of Hailbytes, and we were talking to a lady who specifically does code review of software, and she was kind of bemoaning the fact that not enough companies actually do code reviews. And here it is in black and white. If you have software, you need to think about doing a code review, or the FTC could come in and hammer you for the next 20 years. But I'm getting a little ahead of myself. And penetration testing of InfoTrax network and software. So you should be doing a code review, or at least contemplating, as well as contemplating penetration testing of both your network and your software. Further allegations, they failed to detect malicious file uploads by implementing protections such as adequate input validation, failed to adequately limit the locations to which third parties could upload unknown files onto InfoTrax's network, Failed to adequately segment InfoTrax's network to ensure that one client's distributors could not access another client's data on the network. So maybe some sort of like SQL injection attack, for example. Failed to implement safeguards to detect anomalous activity and or cybersecurity events. For example, they failed to implement an intrusion prevention or detection system, use file integrity monitoring tools to determine whether any files on their network had been altered, use data loss prevention tools to regularly monitor for unauthorized attempts to exfiltrate consumers' personal information outside of their network boundaries. They stored consumers' personal information. We already talked about what that was. Allegedly in clear, readable text on InfoTrax's network. So, once again, if you have all of this PII, what they're really getting at here is, hey, you have this stuff. You need to be holding that information appropriately. Generally, that's going to be through some type of encryption, generally end-to-end. Respondent could have addressed each of these failures, and this is always the funny part, by implementing readily available and relatively low-cost security measures. Now, this business, at least from Dun & Bradstreet, it's about 20 million or so-ish business. I'm not sure exactly how reliable that information is from D&B, but what they're saying here is, hey, they're not asking for the moon. They're asking for low-cost, reasonable cybersecurity measures. So what actually happened in this case? Well, according to the FTC, during a period of almost 2 years, an intruder accessed their server undetected a total of 17 times. So if true, pretty egregious. Thereafter, an intruder began to pull information from their system. One of those databases contained legacy data that respondents failed to migrate to a new product. So what are they really getting into here? You need to have a handle on just what information you're actually holding. And that may sound simple in practice, but it's not as simple, when you really get down to it, because a lot of these companies, you could be holding massive troves of information. So you need to be thinking about, okay, where's all this information we have? Do we still need this information? How is it stored? Is it, appropriately protected? On that same day, an intruder accessed a different file log stored on their server that contained, among other things, even more personal information of consumers, including 600 names and addresses, over 150 social security numbers, 500 unique unmasked payment account numbers with expiration and CVVs, and 16 bank account and routing numbers. Later, in March of 2016, an intruder queried yet another database from which the intruder accessed over 4,100 user IDs and passwords of distributors, once again in clear text. A lot of this, I think why the FTC is probably so angry about this, has to do with things being in clear text. The only reason respondents received any alerts is because an intruder had created a data archive file that had grown so large that the disk ran out of space. Only then did respondents begin to take steps to remove the intruder from their network. So you can see there, the FTC is, I would say, perturbed again because they're alleging that InfoTrax didn't appropriately, look for any potential breaches of their system. It's just when, hey, this file grew so large that their disk ran out of space, they started looking into it, and then they went, oh my God, this is a problem. And it looks like it, allegedly took them quite a long time to figure that out. In March 14, 2016, an intruder compromised the respondent's environment again. So it looks like they had already tried to remove the intruder, then they got breached again using malicious code to collect information through a client's website portal operated by respondent's InfoTrax. The code was designed to harvest payment card and other billing data newly submitted by distributors during the checkout process. So that looks like a specific vulnerability that kind of came out in 2016. I think it's still around. The name eludes me. The intruder thus obtained over 2,300 unique full payment card numbers, including names, physical addresses, CVVs, and expiration dates. So all told by this point, this isn't a massive company. This is not a particularly massive breach per se, just by the numbers that the FTC is alleging here. So that should give you pause that, just because you're not a household name, you're not the Facebooks, the Twitters of the world, that doesn't mean that the FTC is not going to come after you. So then they go through, okay, right here, what's really the injury to consumers? So it looks like All Clear ID, the third-party call center retained by one InfoTrax client to assist with breach responses, had received over 280 reports of alleged fraud from that client's distributors and end consumers, 238 complaints of unauthorized credit card charges, 34 complaints of new credit lines opened, 15 complaints of tax fraud, and 1 complaint of misuse. In addition, that client received reports of potential fraud from approximately 22 distributors and end consumers. So going on, what's the violation that the FTC is saying here? Really going back, unfairness, failure to employ reasonable data security practices. So then they go through here, right? This is as of December 30th, 2019. All right, now let's look at the actual decision and order here. So what was the fallout from all this? What can this company expect to be required to comply with? Well, needless to say, this is going to be painful, and I would urge everybody here to realize this is, there's like a 99% probability that there is no insurance for this, and this is going to cost a lot of money. So it's one of those things where you kind of either pay for compliance and cybersecurity measures now, or you're going to pay for it later. Me personally, I would rather do things on my own time and my own dollar as opposed to some room of unknown government bureaucrats forcing me to do something. But let's get into what actually they're now going to be required to do. And trigger warning here, this is long. This is essentially just 11 pages of legalese of all the things that they're going to have to start doing. So as we scroll through here, and you should keep in mind too that these are all things that you should contemplate actually doing within your own business. Obviously, you don't want the government mandating this. So think about these as, something you should probably talk to your own IT professional, your own compliance attorney, on whether or not you actually need this for yourself. So let's see, a mandated information security program. Each covered business, so that's going to be right coming up here, a covered business means any instance in which any United States, federal, state, blah, blah, blah. So essentially they're getting to InfoTrax. Shall not transfer, sell, share, collect, maintain, or store personal information unless it establishes and implements and thereafter maintains a comprehensive information security program that protects the security, confidentiality, and integrity of such personal information, so essentially PII. To satisfy this requirement, each covered business must at a minimum. So what are they saying here? Hey, unless you do these things, you cannot transfer, sell, share, collect, or maintain personal information. Well, that's what this business does. So essentially they're saying, if you want to remain in business, thou shalt do the following. Document in writing the information security program. Provide the written program and any evaluations thereof and updates thereto at least once every 12 months and promptly after a covered incident. Designate a qualified employee or employees to coordinate and be responsible for the information security program. Assess and document at least once every 12 months and promptly following a covered incident, so say a breach or potential breach. Internal and external risks to the security, confidentiality, or integrity of personal information that could result in unauthorized disclosure, misuse, loss, theft, alteration, destruction, or other compromise of such information. So very broad. Design, implement, maintain, and document safeguards that control the internal and external risks to the security, confidentiality, or integrity of PII. These safeguards so they must also include policies, procedures, and technical measures to systematically inventory personal information stored on corporate respondents' network and delete personal information that is no longer necessary. Measures to assess the cybersecurity risk posed by the respondent's code. So once again, getting back into that code review. Personal information stored on their network, including at least once every 12 months. Software code review and penetration testing. So now they're saying, hey, at least every year, you're going to be doing a software code review and you're going to be doing penetration testing. That's not cheap. Technical measures to detect unknown file uploads, such as input validation. Technical measures to limit the locations to which third parties can upload files on their network. Segmentation of their network to ensure that one client's distributors cannot access another client's data on their network. Technical measures to detect anomalous activity and or cybersecurity events on their network, including an intrusion prevention or detection system, file monitoring tools, data loss prevention tools. Encryption of essentially PII, and authentication credentials such as IDs and passwords. Assess at least once every 12 months the sufficiency of any safeguards in place to address the risks of the security, confidentiality, or integrity of PII, and modify the information security program based on the results. Test and monitor the effectiveness of the safeguards at least once every 12 months. This shall also include vulnerability testing of each of the respondents' networks once every 4 months, and also after a covered incident. So now essentially they're going to have year-round vulnerability testing. Penetration testing of each of their networks at least once every 12 months and promptly after an event or incident. Select and retain service providers capable of safeguarding personal information they access through or receive from each covered business, and contractually require service providers to implement and maintain safeguards for personal information. This may be the biggest pain of all because, first of all, I would just imagine that InfoTrax, after having to deal with this, they're going to make sure that all of their vendors and their service providers have like everything in the kitchen sink required, so that they're not somehow running afoul of this consent order. That being said, that's going to cost a lot of money. That's going to limit the number of service providers and vendors that they can actually access. And I would just assume that it's going to ratchet up the cost here on out for the next 20 years of every single vendor agreement they're going to have. It's just going to cost that much more. And looks like there's really nothing they can do about it. Evaluate and adjust the information security program in light of any changes to its operation or business arrangement. It is further ordered. Respondents must obtain initial and biennial assessments. So biennial being twice a year, if my memory serves me correctly. Must be obtained from a qualified, objective, independent third-party professional. Uses procedures and standards generally accepted in the profession. Conducts an independent review of the information security program. Retains all documents relative to each assessment for 5 years after completion of such assessment. And will provide such documents to the Commission within 10 days of receipt of a written request from a representative of the Commission. No documents may be withheld on the basis of a claim of confidentiality, proprietary or trade secrets, work product protection, attorney-client privilege, statutory exemption, or any similar claim. For each assessment, respondents shall provide the Associate Director for Enforcement for the Bureau of Consumer Protection at the FTC with the name and affiliation of the person selected to conduct the assessment, which the Associate Director shall have the authority to approve in his sole discretion. So now not only do you have to bring somebody in to do all this, the director, this Associate Director, whoever that guy is, can just say no, and he can make you find somebody else. All right, these assessments must cover the first 180 days after the issuance of the order for the initial assessment and each 2-year period thereafter for 20 years. This is a 20-year sword of Damocles, monkey on the back of InfoTrax. You do not want to be in this situation. If you're an info security professional out there, if you're working in cybersecurity, I would just urge you, bring this to the board of directors, bring this to the owners, make sure they're aware of what can happen. If you're having issues dealing with known security vulnerabilities, you're having issues with, getting the right funding you need to do your job appropriately, just bring this video to the owners of the board of directors, bring this up to the CISO and say, hey, this is why I'm saying we need more money to do this, or this is why I'm saying we need that, security assessment or penetration test or code review. It's to avoid being forced to do it for the next 20 years. So what does each assessment, what does it have to entail? Determine whether they have the information security program and the mandated information security program. Identify any gaps or weaknesses in the info security program. Identify specific evidence. Examine to make such determinations, assessments, and identifications, and explain why the evidence that the assessor examined is sufficient to justify the assessor's findings. No finding of any assessment shall rely solely on assertions or attestations by a covered business's management. So now they're saying, we don't care what the management says. It's all going to depend on this assessor, which, if I remember correctly, the associate director of this random arm of some bureau can approve or disapprove, just apparently as he sees fit. I'm not sure what kind of recourse you would have if you're under this consent order If this associate director just goes, yeah, no, I don't like this guy, you're going to find somebody else. It looks like you're just taking in the shorts. Each assessment must be completed within 60 days after the end of the reporting period to which the assessment applies. Moving forward, all right, here we go. It is further ordered. This is cooperation with third-party information security assessor. So this is getting into all the stuff you have to do for that security assessor. Now we're getting into annual certifications. It is further ordered. Respondent shall, 1 year after the issuance date of this order and each year thereafter, provide the commission with a certification from a senior corporate manager. Each covered business has established, implemented, and maintained the requirements of this order. Each covered business is not aware of any material noncompliance that has not been A, corrected, or B, disclosed to the commission. 3, includes a brief description of any covered incident. The certification must be based on the personal knowledge of the senior corporate manager, senior officer. Now, personal knowledge or subject matter experts upon whom the senior corporate manager or senior officer reasonably relies in making the certification. Now, once again, the FTC is getting back to that term reasonable. Now, if I was a senior corporate manager or senior officer, my new definition of reasonable would be totally different. So I would just imagine this is going to be a very stressful endeavor for anybody in this organization, just on top of all the money they're going to have to pour into doing all this. And each time they're going to do this, they're going to be thinking, okay, is the FTC coming back? They actually have gone back on companies who failed to live up to this. Oh, and they have to submit all annual certifications to the commission pursuant to this order. Moving forward, it is further ordered yet again that respondents for any covered business within a reasonable time after the date of a discovery of a covered incident, but in any event no later than 10 days after the date the covered business or any covered business's clients first notifies any U.S. federal, state, or local government entity of the covered incident, must submit a report to the commission. The report must include, to the extent possible. So now they're saying, hey, when an incident occurs, you have 10 days to get your attorney, get your InfoTrax professional, and give us all this stuff, which is lengthy. Oh, but wait, it doesn't stop. Acknowledgements of the order. It is further ordered that respondents obtain acknowledgements of receipt of this order. So now this thing, it just keeps going. We're on page 7 of 11 of a litany, just a list of things that are now required. So each respondent within 10 days after the effective date of this order must submit to the commission an acknowledgement of receipt of this order sworn under penalty of perjury. So don't screw this up or you could go to jail/prison. For 20 years after the issuance of this order, individual respondent for any covered business that individual respondent individually or collectively with any other respondents is a majority owner or controls directly or indirectly in corporate respondent must deliver a copy of this order to all these people. From each individual or entity to which a respondent delivered a copy of this order, that respondent must obtain within 30 days a signed and dated acknowledgement receipt of this order. Yikes. But oh wait, we're not done. Compliance reports and notices. It is further ordered that respondents make timely submissions to the commission 1 year after the issuance date of this order. Each respondent must submit a compliance report sworn under penalty of perjury in which each respondent must, blah, 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 describe in detail whether and how respondent is in compliance with each provision of this order, including a discussion of all the changes respondent made to comply with the order, and provide a copy of each acknowledgement of the order obtained pursuant to this order. You can rest assured that an attorney, I would just imagine, is going to be working with each respondent here, and that attorney is not going to be cheap. Each respondent must submit a compliance notice sworn under penalty of perjury within 14 days of any change in the following. Yada, yada, yada. Got a lot going on there. Record keeping. It is further ordered that respondents must create certain records for 20 years after the issuance date of the order and retain each such record for 5 years unless otherwise specified below. They must create and retain the following records. Accounting records showing the revenue from all goods or services sold, the costs incurred in generating those revenues, and resulting net profit or loss. Personnel records showing for each person providing services in relation to any aspect of the order, whether as an employee or otherwise. That person's name, address, telephone number, job title, position, dates of service, and applicable the reason for termination. What a nightmare to keep track of this. Copies or records of all consumer complaints concerning the subject matter of the order, whether received directly or indirectly, such as through a third party in any response. For 5 years after the date of preparation of each assessment required by this order, all materials and evidence that the assessor considered, reviewed, relied upon, or examined to prepare the assessment, whether prepared by or on behalf of respondents, including all plans, reports, studies, reviews, audit trails, policies, training materials, and assessments, and any other materials concerning respondents' compliance, blah, 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 for 5 years from the date received, copies of all subpoenas and other communications with law enforcement, if it relates to the compliance with this order. For 5 years from the date created or received, all records, whether prepared by or on behalf of respondents, that tend to show any lack of compliance by respondents with this order. Now, what in the hell does that mean? That tend to show any lack of compliance? I just imagine they're going to keep everything in redundancy. So that's going to cost even more money. All records necessary to demonstrate full compliance with each provision of this order, including all submissions to the commission. Compliance monitoring. Oh, we're not done. We're only on page 10. It is further ordered that for the purpose of monitoring respondents' compliance with this order, blah, 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 blah. So you got more there. Now, just right here, this order will terminate 20 years from the date of its issuance. So what do we have here? We have, if my memory serves me correctly, we're going to have code reviews. We're going to have vulnerability assessments. We're going to have penetration testing. We're going to have just a litany of things that are very expensive. You're going to have all of these particular, administrative burdens placed upon the business. And at any time, it looks like the FTC can just come back in and say, hey, show us your stuff. Now, this is as of December 30th, 2019. Keep in mind that these were allegations made by the FTC. I have not seen any reply from InfoTrax. So once again, all allegations here. But the gist of it is you don't want to be this business. You don't want to be the CISO of this business. So needless to say, take this seriously. Get a compliance attorney, right? Seriously consider that. Figure out what it is you need to do to have reasonable cybersecurity measures, and don't skimp on cybersecurity funding, because the FTC will come after you, and it could be very painful. All right, with that, if you enjoyed this video, like, share, subscribe, spread to all your friends, keep them out of trouble, and with that, stay safe.